How do you analyze a negligence issue on a tort essay question? Well, remember in our first two videos on negligence, we said that your analysis was going to be centered on 4 elements: duty, breach, causation, and damages. In our first two videos, we've been primarily focusing on the first element, which is duty. Specifically, remember we broke duty down into 2 parts. Number 1, whether the defendant owed the plaintiff a duty of care, and number 2, if so, what level of care did the defendant actually owe the plaintiff? And remember, we said the starting point was the reasonable person standard of care. This is your default standard of care. Unless the defendant falls into a special class or a statute is defining a standard of care as a matter of law, this is going to be the standard that you apply, which is what would a reasonably prudent person do under like circumstances as measured by an objective test. But remember, I said it's best to think about this as a spectrum. The standard of care can be raised for certain classes of defendants. Maybe, for instance, you had physicians. Remember, I said that physicians might be held to a higher standard because of all the medical training that they have, the stakes involved, they have patients' lives in their hand. So we might hold physicians to a raised standard of care. And remember, I said children that are engaged in non-adult activities, children may be held to a lower standard of care. And if you want more information on this spectrum and different classes of defendants, I'll put all of that down below because there's lots of classes of defendants that could change where the analysis falls on this spectrum. And rather than going over each one line by line in this video, I just would rather have you look at all of that information. Most of the analysis are going to be changed very slightly. It's very easy to just read about them. But there's one class of defendant that I think is so special, has such a complicated analysis that it does warrant making its own video. That is the purpose of this chart that you see here. That's what we're going to go over. And that is defendants who possess land or own land, okay? In the situation where you have a plaintiff suing a defendant for an injury or harm suffered while on a landowner or land possessor's land, right? This is typically, imagine a slip and fall case in a grocery store, right? If you've ever been to a grocery store and you've seen a spill on the ground, like someone spills a gallon jug of milk and it goes everywhere, what does the store do relatively quickly, right? They'll send an employee out there to put one of those big yellow warning signs on the ground that says, warning, this is slippery when wet, caution, watch your step. And generally they're going to get someone out there squeegeeing that milk away pretty quickly. And why are they doing that? Because of this standard of care. They owe you a duty to make that hidden danger, that spilled milk, safe. And that is the heart of this duty of care analysis when it comes to landowners and land possessors. But let's break it down. So if you're a landowner or a land possessor, which probably most of you watching this are, if you rent an apartment, you own land, you own a home, you're a store owner, maybe you have a small business, something like that with patrons, this all is going to apply to you when there are entrants on your land. So there's 3 duties that you should think about. 3 duties of care, so to speak, that a landowner or land possessor may owe to entrants on their land. Number 1, we have a duty to inspect the land for hidden dangers. A duty to inspect. We have a duty to warn. Is there a duty to warn entrants of known hidden dangers on the land? And finally, there's the duty to make safe. To make safe hidden dangers on the land. So these are kind of your 3 duties you should think about. A duty to inspect the land, a duty to warn of hidden dangers that are known, and a duty to make those dangers safe. So for instance, a duty to inspect, sticking with that example, if you're a store owner, a grocery store owner, you have a duty to reasonably inspect the premises. Anytime you're having patrons come into your store, you're going to have a duty to inspect your store, your premises, your land for hidden dangers. You're going to have a duty to warn and make safe. If you discover hidden dangers, you're going to have to make those safe by putting that warning sign down or squeegeeing the milk, whatever it is, whatever that hidden danger is, once you become aware of it from your inspection, and it's got to be a reasonable inspection, you have a duty to warn and make safe. Okay, but let's break this down even further. Imagine that you're not dealing with a patron in your store. There are different statuses of entrance. So here I have T, L, and I listed. Here's your three main types of entrance. This T is for trespassers, this L is for licensees, and this I is for invitees. And it's important to understand the difference here. Everybody knows who a trespasser is. A trespasser is somebody who's entering your land without your consent or your permission to do so. That's generally what a trespasser is going to be. Now, for our purposes in this analysis, there are two types of trespassers, a class within a class. I know this is confusing, but trespassers, you have what are called discovered trespassers and undiscovered trespassers. An undiscovered trespasser is an unforeseeable trespasser. Someone you have no idea is going to be trespassing on your land. They're unforeseeable. And if you remember from our first video, what did we say about unforeseeable plaintiffs or unforeseeable victims? Right? Do you owe them a duty? Generally, no. So if you're dealing with a fact pattern where the trespasser is unforeseeable, you don't even have to worry about any of this chart or question number 2. The defendant does not owe an unforeseeable trespasser a duty of care. This first part of the analysis is going to fail. So you don't have to worry about this. With trespassers, we're only thinking about what are termed discovered trespassers, which is basically foreseeable trespassers. What's a foreseeable trespasser? The usual example of this is somebody who is trespassed on your land before. They're a known trespasser. That's why we say discovered trespasser. Somebody who keeps using your land over and over again. Imagine that you own a big farmland and people constantly use a trail without your permission somewhere on the back of your property. You know this is going on. You don't really stop them, but they don't have your consent. So maybe they're trespassers, but they are foreseeable. You know this is happening. That would fall into this class of foreseeable trespassers. So here, next to this T, I'm just going to briefly draw a little discovered, right? Right here, we're only talking about discovered trespassers. Trespassers who are foreseeable. Okay, so next you have licensees. What is a license? This is a person who has a license to use your property, which in most cases is just going to be a social guest. This is somebody who's on your land for their own benefit. Think of somebody, you host a party and someone's coming to enjoy your party. You, the landowner, are receiving no benefit from this individual. So they are a licensee. If they're not conferring a benefit to the landowner, they're not an invitee, they're a licensee. This is generally going to be a social guest, right? Invitees, on the other hand, are patrons to a store. They're people who are conferring a benefit to the landowner. If there's mutual benefits on both sides, that's going to be an invitee. Okay, so basically, in short, we have trespassers, we have social guests, and we have store patrons. Okay, and the duty of care goes up for each one of these. And I'll draw it out on this chart for you, but just as a note in your head, obviously you're going to owe the lowest standard of care to trespassers, the highest standard of care to invitees, patrons at your store, and a middle standard of care to licensees, right? Social guests, okay? There's one more variable on this chart that we also have to clear up before we continue further. You see these N's and A's listed. That stands for natural conditions and artificial conditions. On land, there can be naturally occurring hidden dangers and artificial hidden dangers. Naturally occurring hidden dangers are things caused by nature. This is, a hole in the ground that's concealed by some shrubbery or something, right? That would be a natural condition. An artificial condition would be spilled milk on the ground, right? That's man-made, or an electrical box that's exposed as wiring going everywhere that could electrocute people. Artificial condition. Natural conditions, think, quicksand or hole in the ground. I don't know. Naturally occurring in nature, natural conditions. Okay, so hopefully we understand all of these variables. Once you understand these variables, you just have to fill in the chart, and the analysis is pretty straightforward. Okay, remember, duties at the top, a duty to reasonably inspect the land, a duty to warn of known hidden dangers, and a duty to make safe known hidden dangers. We have the idea that hidden dangers, though, can be naturally occurring or artificial. That might change the analysis a little bit. And we have 3 statuses of entrants. Trespassers, technically 4 if you can also consider undiscovered trespassers, unforeseeable trespassers. But remember, no duty is owed to them. So they don't even get on this chart. No duty is owed to an undiscovered trespasser. We're only talking about discovered trespassers, foreseeable trespassers, trespassers that the landowner or land possessor might know about. And then we have licensees, who are social guests, and invitees, who are going to be people like store patrons, okay? That is all the variables. So let's just try to fill this in nice and easy. Okay, so does a land possessor owe a duty to inspect the land for discovered trespassers? These are foreseeable trespassers. The answer here is going to be no. No duty to inspect is owed to discovered trespassers. You don't have a duty to go out on your land and look for hidden dangers for discovered trespassers. No duty to inspect. Do you have a duty to warn? So if you know there's a hidden danger on your land, do you have a duty to warn? Only if the hidden danger is artificial. If it's an artificial condition, like exposed electrical wires or something that is man-made, you do have a duty to warn entrants, trespassers, discovered trespassers of that artificial condition. Naturally occurring conditions, no duty to warn. You have no duty to warn discovered trespassers of naturally occurring conditions, hidden dangers on your land. Do you have any duty to make safe? Do you have any duty to make these hidden dangers safe for trespassers? The answer here is going to be no. There's no duty to make safe. So the only thing that you owe to a discovered trespasser is a duty to warn, okay? And there's one other caveat for trespassers that I couldn't fit on the chart. And if anybody knows how to draw this chart better, please make the PDF, send it to us, email below. I've been using this chart for years now, and I'm always hoping to a better way to explain this. But one more note for discovered trespassers is that you're only looking, when you're thinking about artificial conditions, you only have a duty to warn about artificial conditions that pose a risk of serious bodily injury or death. So we're thinking about basically hidden artificial death traps on the land. It can't be like a puddle on the ground or, a little 2-foot hole or something. I mean, it's got to be something that could seriously injure the trespasser or kill them. That's what you're going to have a duty to warn against. There's no duty to warn about a puddle on the ground, things that could cause harm, but not serious bodily harm or death. So that's the only note. And note that that's going to be different than licensees and invitees. Licensees and invitees, these duties are going to involve anything that could cause harm. It doesn't have to be serious or, death related. It could just be anything that could cause harm. But for discovered trespassers, we're only focused on artificial conditions that could basically kill you or maim you, cause serious bodily harm. Think like exposed, but kind of hidden, electrical wires, high voltage, like a power line has fallen over and is covered by shrubbery. And people trespass there. Pretty rare instance that's gonna happen, but on a tort essay question, that is something that a grader, an examiner would love to conjure up in a fact pattern, right? Okay, so next we have licensees. Remember, licensees are social guests. Do you have a duty to inspect your property, your land, the land that you either own or possess for hidden dangers before a social guest comes over? The answer is going to be no and no. You have no duty to inspect. Okay, do you have a duty to warn? So if you don't have to inspect, but if you know there's a hidden danger, do you have a duty to warn your social guests? Yes. There is going to be a duty, and it doesn't matter if it's natural or artificial, you have a duty to warn. Now, you can also make safe, right? Making something safe is better than warning, so this would also suffice. So I'll put circles here and a little line right there. That just represents that you can warn or make safe, but at minimum, you have to warn the social guest of the hidden danger, right? And remember, it's any hidden danger that poses an unreasonable risk of harm. It doesn't have to be serious bodily harm or death. Anything that could harm a social guest, you have a duty to warn, whether it's naturally occurring or artificial, okay? Now, you could also make it safe. I mean, if you actually corrected it and made it safe, that's even better than warning, so that'll work too, obviously. So we have these little O's there to delineate that this is an or. You can warn or make safe. Finally, we have invitees. These are patrons at a store, generally, right? Someone who's conferring benefit to the landowner. An entrant who is conferring benefit to the landowner. Do you have a duty to inspect your land? Yes. There's going to be a duty for landowners or land possessors to inspect the land for natural or artificial hidden dangers that pose a risk of unreasonable harm, right? So you have a duty to inspect. If you're a store owner or a small business owner, you own land that people are coming to and conferring a benefit to you, generally a store owner, you have to inspect that land for hidden dangers. If you discover hidden dangers or you are made aware of hidden dangers, do you have a duty to warn the invitee? Surprisingly, no. There's no duty to warn. Why is that? Because you have a duty to make them safe, right? Warning is not enough. You can't just warn a store patron. You actually have the duty to make that danger safe. So warning will not suffice. You have to make it safe. That's going to apply to naturally occurring or artificial conditions. And this is why, if you've ever been to the grocery store and why I kind of opened with this example, you're going to see stores quickly fixing hidden dangers, whether that's spilled milk on the ground, spilled water, any kind of small to big things. Stores are going to be very quick to correct the danger because they owe you, the patron, a duty of care to do that. It's very important that they do it or they're breaching the duty of care they owe to you as a land possessor or a land owner. Okay, so this chart, again, will be below. I know with the light, sometimes it's hard to see what's written. I'll try to get out of the way a little bit here. But this is basically what your analysis is going to look like if the defendant is a landowner or land possessor and the plaintiff is somebody who is injured on the land by some sort of danger on the land. Okay, I know it's confusing. Hopefully this chart lays it out. One final note before I sign off here on this standard of care to landowners and land possessors, and that is going to be that everything I just discussed here is the traditional approach, okay? Some jurisdictions have rejected this. They've rejected the distinction between licensees and invitees. And they say, you know what, instead of applying this big confusing chart with all these varying duties and artificial and natural conditions, let's just throw that out the window and apply the reasonable person standard of care, right? How easy is that? So after you discuss this on a torts essay, that is the traditional approach. You'll want to go back and apply a reasonable person standard of care. Now, ironically, again, it's one of those things where you'll probably come to a very similar conclusion because all of these things would be factors in a reasonable person standard of care analysis. Nothing would be conclusive like it might be under this chart for the traditional approach, but they're all going to be factors because a reasonably prudent person would probably treat trespassers, licensees, and invitees a little bit different. What's considered reasonable for the different status of entrant and these different duties right, is all gonna change for what the reasonable person standard of care would be, but they just become factors, not anything conclusive. That's the modern approach. Traditional approach, you gotta stick to this chart and bang it out. Whew, okay guys. So that's what you're going to do if the defendant is a land possessor or landowner. Remember, this is just dealing with this idea of the spectrum. Starting place is the reasonable person standard of care, but if you have a certain class of defendant, like a landowner or a land possessor, the analysis can change on this spectrum. Okay, so in our next video, hopefully, I think this wraps it up, and below I'll include some other classes of defendants and how that will affect the spectrum. But that should conclude the second part of the duty analysis. So from here, we can move on to breach and causation and hopefully eventually get to damages. But until then, guys, I will wish you all the absolute best, and I'll see you at our next video.